you think of Medicare, the next thing you might be thinking about is Medicaid. So there are some distinctions between the programs. Again, Medicare is usually associated with people who are older, retirement age, or perhaps on Social Security disability for some time. Medicaid is a different program. A lot of it is funded by federal money, but it's administered at a more local level. And Medicaid is commonly associated with people who are low income. Medicaid also has rights of reimbursement attached to money that they pay out or those programs pay out for accident-related medical care. But the rules can be a little different. The way I practice in this area is that I do affirmatively notify Medicaid when I have clientele who are involved in personal injury matters. And this isn't something I just devised or divined on my own. This was something that was adapted over years through consultation with experts and, in fact, lawyers and firms who specialize in these areas, and also just my understanding of the law. So much like I would tell Medicare beneficiaries that they should not set aside a case or discontinue a case just because they're concerned about how much Medicare may need to be reimbursed, I would talk to a Medicaid beneficiary the same way. That should not stand in the way of someone moving forward with a personal injury case. But there are some additional considerations that have to be factored in. Medicaid beneficiaries usually have income restrictions that continue to keep them eligible for Medicaid. So, for example, you can only earn so much and maintain your eligibility for Medicaid. If you come into a large sum of money, there might be some temporary interruption of those benefits. It can all vary from county to county, which oftentimes are how the Medicaid benefits are administered. But there's also a marketplace online for people to sign up for these types of benefits through the state of New York, or like I said, the marketplace is how it's generally referred to. I do notify Medicaid programs when I have clientele who are beneficiaries that have personal injury cases. There are some very strict rules, though, that the departments of social services or similarly named the departments, the name of the department for what it was usually referred to as DSS has evolved and changed over time, and it varies from county to county. But they have certain steps that they are obligated to take to attach their lien or to establish their lien if push comes to shove. There's certain documents that need to be mailed to people like myself and my clients. There are certain documents that need to be filed with the county clerks to establish without question the righteousness, if you will. That's not the right word, but the applicability and the eligibility of that lien for the county, the departments of social services. There is some give and take. Some lawyers do handle things differently. But again, the way I have learned, the way that I have been instructed by people I trust who are experts in this field, is that it is best to deal with it upfront or affirmatively. Don't wait for a case to be over. Don't wait for the end of a case to figure out how much Medicaid may have paid for your client's accident-related medical care. The real reason why you shouldn't do it is because, much like you don't want to play hide and go seek with Medicare, you don't want to do that with Medicaid either. You don't want to do anything that's going to foul up your client's eligibility for Medicaid at some time after the case is over. If the local government or the county Department of Social Services office finds out that a recipient came into a large sum of money, but it was never recorded, and they never were repaid for accident-related medical care, and they're only finding out about it after the fact, you can probably figure out the problems that could cause. It could foul up continued eligibility. It could obviously involve the county DSS office establishing a lien and looking to be repaid. Maybe that money is already spent by the client. It's just not a very attractive situation to get into. When I was a younger attorney, I was always very worried and very, very nervous about speaking to clientele about repayment obligations. But after 26 years, it's become second nature. And from what I've learned, most people completely understand it. Once in a while, there's someone who is kind of dumbfounded and a little irritated by that, but that's the exception. Most people get it. Most people understand that the benefits that they are being paid are not their own money. It's taxpayer funded. It's coming from the government, and they kind of have an acceptance of it. Some people are a little more resigned in that acceptance, but most people understand it. It's just part of how it works. That's not to say that Medicaid should be repaid penny for every single solitary thing. There are instances where exceptions can be made, amounts can be lowered. Sometimes cases involving children bring up some of those exceptions. Sometimes cases involving estates can bring up some of those exceptions. But at the same time, it's something that generally has to be dealt with throughout the pendency of a case. You don't want to wait. Lawyers usually do not want to wait until the end to try and figure that out. It can just cause problems with the clients. It can deflate expectations when numbers are being discussed, only to have to factor in something that wasn't considered before. So the general rule of thumb that I have for managing cases involving Medicare and Medicaid elements is to deal with it upfront, establish the communication with the agencies sooner rather than later, and start embracing those numbers and building them into the settlement demands or the ask, and if necessary, being prepared to show those medical costs to the clients in court.